Thank you so much for joining us today. I'm Valerie Gonzalez. I am the owner and principal attorney of San Gabriel Valley Law, and I welcome you today to this webinar. San Gabriel Valley Law is the human resources law firm protecting California business owners. Prior to becoming an attorney, I was a human resources professional for a decade, and now my firm leverages that experience to provide focused legal protection in the areas of both culture and compliance, solely serving California small business owners. Before we begin, what would a free webinar be from an attorney without a couple of disclaimers? As a reminder, this call is being recorded, and by attending, you are consenting to that. This information is not legal advice, and it doesn't replace the advice specific to your business from an attorney. This information is intended for California audiences only, and there is no attorney-client relationship simply by attending this webinar. All right, let's get started. Our call today will last no longer than 45 minutes. Because of the amount of information provided today, we will unfortunately not have time for questions, but at the end of the presentation, we will include information on how to schedule a legal strategy session with us. Within those 45 minutes, I will break down the 5 most common reasons business owners get sued, how these lawsuits bankrupt their businesses, what you can do to avoid becoming the next statistic, and the single choice smart business owners make to change whether or not a lawsuit is simply a nuisance or devastating and door closing to your business. All right, so let's start with the bad news. Are you ready? Here's the bad news. 1 in 2 business owners in California get sued every year by their employees. That means if you're a business owner on this call today, you have a 50% chance of getting sued this year if you have employees. That is only speaking about lawsuits and not the fines and penalties that can be brought against you due to the EEOC, DOL, or EDD claims that can be filed against you. Of those lawsuits filed, business owners will overwhelmingly lose the vast majority, 67% to be exact. This is because the laws in California are created to protect employees, and so business owners are truly fighting an uphill battle. This means they must be more strategic than ever in California in order to avoid becoming the next statistic. All right, let's break down the 5 most common reasons California small business owners get sued and how to avoid them. including a bonus number 6 at the end. So if you make it to the end, you're in for a bonus number 6. Now, these are listed in no particular order. Here we go. Number 1 reason, terminating an employee without a valid reason. So California is an at-will state, which generally means that an employee can be terminated, fired, let go, laid off for any reason at any time, except one that violates the law or a contract. In the same way, it means an employee can end their own employment for any reason at any time, except for one that violates the law or contract. Where employers go wrong on this is when they terminate employees who have a contract that says they can't be terminated except for specific reasons, and when they act in emotional instead of logical ways. For instance, when I was a human resources professional, I joined a company who was right in the middle of fighting a multi-million-dollar wrongful termination lawsuit after they fired a long-term employee. Now, remember, in California, you can fire employees for any reason except one that violates the law or a contract, right? Well, the former employee was alleging that they did have a contract that said they couldn't be fired, and the company breached that contract when they fired him. What was the contract, you asked? Well, it was a series of repeated comments over time where the boss told the employee that he would have a job with him for life. Now, does that count as a contract? Possibly. The company says they fired him due to poor performance. The employee says they fired him due to discrimination because he had just come back from a medical leave of absence. So how does an employer fight claims like this? Well, we build upon a solid foundation. That foundation, as a business owner, should begin with job descriptions for every single position, an employee handbook, and employee agreements. All of these should be signed by each employee and reviewed by the business owner every year. Job descriptions, handbooks, and agreements are the foundation upon which everything builds. They are evidence to defend you in a lawsuit. And even prior to that, they help your employees understand their job and what is required of them. Once you have those in place, you refer to them during conversations where you must correct employee performance, and they provide the basis for termination. All right, here's reason number 2. Reason number 2 is not understanding and complying with wage and hour laws. A wage and hour lawsuit essentially costs $100,000 up into the multi-million dollars. So California wage and hour laws are notoriously some of the most difficult in the nation. Wage and hour laws include laws pertaining to meal breaks, time tracking, classifying workers, overtime wages, incentive pay, split shift pay, and many others. On top of that, every industry and many counties have their own separate wage orders employers must know and follow. California wage and hour laws have many nuances, and consistently applying them is truly a battle of trial and error. The problem here is that the trial and error can be extremely costly and absolutely devastating. Because typically when there is one wage and hour violation, it snowballs into many, many more because it's assessed per violation, per occurrence, and per employee. Additionally, the courts will look back and award damages for 3 or more years, depending on jurisdiction. So one missed meal break for one employee can quickly turn into many violations over a period of time. When you have multiple employees who aren't getting paid correctly, aren't be giving their meal break, aren't being paid overtime at the correct calculation, it can turn into a class action lawsuit, which can drive the money damages up into the multi-millions. In 2019, the top 10 employment lawsuits in California had damages of $15 million to $98 million. Compliance with wage and hour laws require vigilance, and it requires consistent auditing and human interaction. You cannot rely on an algorithm or your payroll system to correctly comply. Your payroll system has no critical thinking skills and does not consistently interface with your employees, which is what is required. You must have systems set up and a trained, dedicated human resources person monitoring it if you hope to comply. All right, reason number 3, not keeping up with the ever-changing California laws. California has a lot of employment laws. Did I shock anyone? I hope not. Currently, there are over 26 employer-specific laws for business owners who have even just one employee. Additionally, federal law has over 180 employment laws that must be followed. Many business owners think that because they only have a small amount of employees or less than 5, they don't have to comply with that many laws. That is a false belief, and you will be fined and penalized for non-compliance. Fines and penalties in this area can run between $1,000 to $25,000 per violation, per employee, per occurrence. And that's not including a lawsuit. More than 20 new laws are introduced every year in California that specifically affect your role as an employer. So on top of having lots of laws, they change all the time. And every year, new ones are introduced that directly affect your role. How do you keep up? And how do you find the time? Additionally, your industry, your county, and your business type have ordinances you must follow as well. These are different from established laws we just spoke about and are introduced at various times. Just in the last 4 months, for instance, in LA County alone, we saw 2 huge emergency orders and public health orders pop up in regards to vaccine mandates and COVID-19. All right, reason number 4, misclassifying workers. Legislative trends indicate that workers as independent contractors is not favored, and this is only reserved for a select few individuals. In the past 9 months, new laws have been passed which indicate that our state is continuing to move away from classifying workers as independent contractors in favor of making workers employees. Independent contractor status is truly reserved only for a select few and should not be the default for business owners to hire workers. Business owners should steer away from hiring people as independent contractors unless they've consulted with an attorney in their area. Penalties and fines can range between $5,000 to $25,000 per violation, not counting a private lawsuit. These penalties and fines come from EDD, the Workers' Comp Board, and the Department of Labor. Workers can also sue the employer directly. Reason number 5, not understanding reasonable accommodations. The California Fair Employment and Housing Act requires employers of 5 or more to provide reasonable accommodations for individuals with a physical or a mental disability unless it would cause an undue hardship. Currently, there are 2 reasons an employee can request an accommodation. 1, due to disability, or 2, due to religion. This can turn into modified job duties or result in a leave of absence. The term undue hardship includes any accommodation that's unduly costly, extensive, or substantial to you, or that would fundamentally alter the nature of your business operation. So, for instance, if an administrative assistant who doesn't see clients and works at an office requests to work from home temporarily as an accommodation for her medical condition, and she already has all the equipment to do so, this would not likely be seen as an undue hardship, right? On the other hand, if a cashier in a grocery store requests to work from home, they likely can't ring up customers from the comfort of their own home. Thus, it would likely be an undue hardship because that would fundamentally alter the nature of your business operation if you required customers to swing by the employee's house in order to check out of your grocery store. When it comes to religious exemptions, you're touching on issues of constitutional law that you don't want to be in the news about. It's best to consult legal counsel whenever you're dealing with issues of religious exemption. Here's the point. The point is that these are very fact-driven scenarios and truly case by case basis reviewing these facts. Additionally, none of this can be correctly administered without that proper foundation we spoke about at the beginning of job descriptions, employee handbooks, agreements, and policies and procedures. You must first lay the proper foundation so you can uphold it. Lawsuits for not understanding reasonable accommodations and thus not correctly administering them cost between $100,000 up into the multi-million dollars. All right, but here's the good news. Finally, right? Here's the good news. While no one can promise you that you won't get sued, you can begin building your defense today with a comprehensive and proactive legal strategy. I promised you a bonus number 6, and here it is. This is the mistake that business owners make. Ready? Bonus number 6. The mistake business owners make is thinking that they can't afford a legal strategy when they really should be thinking if they can afford not to have one. Given everything we've explored together, all the facts, all the statistics, as an employer in California, you have to change your approach and your thinking if you're going to survive when all of these laws are pro-employee, not pro-business owner. You cannot fight legal problems with non-legal methods. Only a legal strategy will suffice. So what is a legal strategy? Well, a legal strategy is the single decision smart employers make to protect their business from devastating door-closing employee lawsuits. And San Gabriel Valley Law's goal is to provide an accessible legal strategy to the average California small business owner. A legal strategy encompasses these 4 things. Number 1, building a strong foundation. We spoke about this at the very beginning and multiple times throughout this call. This is where we start. We have to have comprehensive, clear policies, procedures, job descriptions, contracts, agreements. This is our evidence in court and the rules that govern our business. Our business is built on top of these. Number 2, legal strategy encompasses wise counsel. This is dedicated, experienced, employer-specific support that you can turn to run fact-based scenarios by, gain insight and counsel on tough situations, and approval of decisions before you make lasting, permanent decisions. Number 3, a legal strategy encompasses systems. Internal systems that build on each other to provide layered safety nets so one single act or non-act doesn't crumble the entire business. And number 4, a legal strategy encompasses peace of mind. By relying on professionals, you're relying on our experience, knowledge, and skill. A comprehensive legal strategy provides you peace of mind. All right, remember bonus number 6, the mistake business owners make is thinking they can't afford a legal strategy when they should really be thinking if they can afford not to have one. So here's the breakdown, here's the numbers. It costs $50,000 and up to settle a lawsuit. It costs $150,000 and up to defend yourself in a lawsuit. It'll cost $300,000 if you win a lawsuit, and $300,000, excuse me, to lose a lawsuit because of the attorney's fees you'll spend in doing so, not to mention the stress and time. So win or lose, $300,000. Investing in a legal strategy, however, starts as low as $1,500 per month, and it gets you up to 4 hours of dedicated legal advice and strategy per month. Has flexible terms, flat fees, no hidden costs, provides you direct attorney access for your most important questions. It includes a comprehensive compliance audit every year and 20% off projects and any other services that you may need. So what do you think? Can you afford not to have a legal strategy? In 1968, my grandpa and grandmother opened a small corner store off Huntington Boulevard in East LA with the dream of supporting their family. This picture was taken about 20 years prior at their wedding. That corner store in East LA provided income for my grandparents to financially support their 6 children and the flexibility needed to logistically support such a large family. Back in 1968, laws were much different, as you could imagine, but legal protection was not accessible to them. And because of that, they were taken advantage of many times, eventually resulting in the loss of their business. At San Gabriel Valley Law, our goal is to make excellent legal protection accessible to the average California business owner, not unlike my own grandparents, so that employers can run their business the way that they want to with the confidence and peace of mind that they are protected. If your dream is like my grandparents to build a business and a legacy your family can rely on, don't wait to become the next statistic. Visit our website or call us today and schedule your legal strategy session. Get your business some protection and get yourself some peace of mind. Thank you so much for joining me today. You'll receive follow-up information on how to access today's recorded call and how to schedule your legal strategy session. We hope you have a wonderful day.